Hearing in the Integrity Commission appeal.
Ms. Minute Phillips, Mr. Missick, good morning. It's very early in the morning for you, I think.
Good morning.
Good morning, my lords.
It seems to us that the time which has been allowed for the hearing of this appeal is very generous. Indeed, some of the issues have now been dealt with. The issue of consent of the persons in public life is a matter which has now been resolved. There's a letter received by the court dated the 27th of October from the respondents, and the respondent has indicated that it will consent to a variation of the order to remove the words "and with the consent of the person in public life." Similarly, the issue as to whether functions includes powers seems to us to have gone away. That leaves the central issue as to the scope of Section 20 and the issue in relation to confidentiality, and on which we will look forward to hearing you. It does seem in those circumstances that the time allowed is over generous.
Yes, my lords, I will certainly shorten the time to make allowances for those changes.
Thank you very much. Ms. Minute Phillips.
May it please you, my lords, this appeal raises issues of... I'm sorry, I wasn't sure if your lordships had indicated that I was...
Yes, please. Yes.
May it please you, my lords, this issue raises issues of statutory interpretation, and in particular, the Integrity Commission Ordinance of the Turks and Caicos Islands. At the heart of these issues is the Integrity Commission's power to summon persons to attend before it at one of its sittings and to give evidence, and also to call for the production of books, plans, and documents. I would ask your lordships to go with me to, at page MS 291, you will see that the Integrity Commission of the Turks and Caicos Islands, I'll just say TCI for short if you don't mind, is one of the 6 institutions expressly recognized in the 2011 Constitution of the TCI and charged with protecting good governance in the islands. I direct your lordship's attention to section 97(1)(e), which mentions the Integrity Commission specifically as one of the 6 institutions. And I also would like to direct your attention to subsection 2. In the exercise of their functions, each of the institutions protecting good governance and any person acting on its instructions or on its behalf shall not be subject to the direction or control of any other person or authority. I would also like your lordships to turn with me to MS page 294, at which you should have section 102 of the Constitution, which specifically deals with the Integrity Commission of the Turks and Caicos Islands. And I'll ask your lordships to look at subsection 2 of 102. Subsection 2 states that the primary responsibility of the Integrity Commission shall be to promote integrity, honesty, and good faith in public life in the islands. I then ask your lordships to kindly note, while there, that subsection E states that the Integrity Commission shall have and exercise such other functions for the purpose of fulfilling its primary responsibility, that is, of promoting integrity, honesty, and good faith in public life in the islands, as may be conferred on it by law. I also ask your lordships to look while there at subsection 5. Subsection 5 says, further provision relating to the establishment and operation of the Integrity Commission may be made by ordinance, but such legislation shall not derogate from any provision of this section. And this section, of course, is the section that states the primary responsibility being to promote integrity, honesty, and good faith, etc. It is submitted, therefore, my lords, that it would have been incumbent upon both the Court of First Instance and the Court of Appeal in construing the Integrity Commission Ordinance to do so in a way that recognizes and supports the discharge of the Commission's primary responsibility, and not in a way that derogates from anything in Section 102 of the Constitution. Before I leave the Constitution to drill down to some relevant contextual detail matters, permit me, if I may, to make two additional observations in relation to the TCI 2011 Constitution, which your lordships know replaced the prior 2006 Constitution. These things in the appellant submission underscore the importance, some even say primacy, of good governance in the TCI, to Her Majesty. The first is the 2011 Constitution's recognition of 6 independent institutions of good governance, functioning alongside each other as a feature of this new 2011 Constitution, which is an expansion of the good governance portfolio beyond that of the Complaints Commissioner that existed in the 2006 Constitution. I give you the page reference if you want to look at it, my lords. It is MS page 222, if you wanted to look at the 2006 Constitution. But if you don't wish to go there, because it merely illustrates what I've said, I would take you to, I ask you to note the second issue, which I think is of some importance, which concerns the governor's reserved power to enact legislation under Section 72(1) of the Constitution, and that is at MS 280. Now, this power also existed under the 2006 Constitution. It was in that Constitution, it's Section 68. But in this iteration of the governance reserve power at 72, there is an introduction of a subsection B to subsection 1, which was not there in 2006. And that subsection B says that the governor has the power to enact legislation to ensure compliance with the statement of governance principles for the time being in effect. So with that introduction of subsection B, my lords, the governor's reserve power could now be utilized, if necessary, to ensure compliance with the statement of governance principles for the time being in effect. At MS 263, your lordships will see that there is a Section 28. Now, this Section 28 was not included in the 2006 Constitution. It's a new introduction. And it is dealing with the statement of governance principles that was referred to in Section 72(1)(b), sorry. And this Section 2028 allows a United Kingdom Secretary of State to issue and subsequently amend a statement of governance principles for the TCI. Of particular interest is Section 28(4), which states that in exercising their functions, all organs of government in the islands shall have a duty to give effect to the statement of governance principles for the time being in effect. And my lords, government in the islands there is to be read to include the judiciary, which is considered to be a branch of the government in the Constitution. And that is clear, for instance, if you look at Section 83(1), you'll see it refers to branches of the government, which make it clear that the judiciary is one of 3 branches. So that said, my lords, with that, I will drill down, if I may, to some of what the appellant considers to be the relevant contextual detail in this appeal. Firstly, it is significant that the object of the Constitution and of the Integrity Commission Ordinance is ensuring the integrity of people who occupy public office and carry out their duties on behalf of the people of the TCI, to whom they are ultimately accountable. And there's even a reference to that in the Constitution at Section 88. But as your Lordship's board pointed out in its Bahamian decision in Douglas and Pindling, which is one of the authorities that is at MS page 449, between letters A and B, that when considering the balance to be struck between private and public interests against and for, respectively, issuing a summons to a banker for the provision of bankers' books to what was in that case a commission of inquiry, the dicta was that the only balance which requires to be made is that between the public interest in the administration of justice or the promotion of the work of a commission of inquiry and the customer's personal interest. If the public interest appears on good grounds to require disclosure, the customer's interest must give way. Now, my lords, the Integrity Commission Ordinance imposes certain obligations on persons holding public office. So if you turn with me to MS 357, you will find there, my lords, a list of specified persons in public life, which is in the Schedule 1 to the Integrity Commission Ordinance. The first category of persons on the list, my lords, is the members of the House of Assembly. I'm not saying their position on the list is relevant, it just happens to make it easy to find them because they're at number 1. But the obligations apply to all persons in public life. So if your lordships look at MS page 359, you turn the page and look at MS 359, you will find the form of the declaration. The specified persons in public life are required to file with the Integrity Commission every 2 years, pursuant to Section 39. And at MS 361, you will see there is a number 1 in the top left-hand corner, and that speaks about the details of income. And then there is a grid at which they would list all the various items that relate to their income. And at 362, you will see number 2, details of assets. And there is similarly a grid there that allows for the declarant to list their assets. And there are 2 following pages of additional grids in relation to assets. And then, or actually more than 2. And then at page 368 to 369, my lords, you see on the form the declaration of liabilities. And the declaration of liabilities is under 3 various heads. The first head is mortgages, the second one is judgment debts, and if you turn the page to 369, you see any other liabilities. And these, of course, are all in grid form. And no doubt that is the first, the declarant listing all the various liabilities that he or she may have in compliance with the law. Now, this brings me to, my lords, the appellant's written case, which is at MS 138. Now, with your permission, my lords, I will just highlight some paragraphs that the appellant finds, you will find useful, and starting with paragraph 19 on MS 144. That paragraph is our paragraph which summarizes the layout Integrity Commission Ordinance. And we say that, generally speaking, parts 49 relate to one or more of the functions of the Integrity Commission set out in part 2 of the Integrity Commission Ordinance in section 13. The procedures set out in part 3 are not, as they could have been had the legislature so intended, contained within any one or other of parts 49. They are separately set out ahead of all of those parts. It is a submission of the appellant that the layout is consistent with the intention that the procedures of the Integrity Commission set out in part 3 of the ordinance are meant to apply as needed to any one of the several functions of the Integrity Commission in section 30 that are additionally addressed or expanded upon in parts 4 through 9. So against the background of that, my lord, I'd like to take you specifically to the Integrity Commission Ordinance and the part that sets out its functions, which is section 13 at NS 320. And there your lordships will see, just under the heading Function of Commission, the functions of the Commission shall be A, to receive and keep on record all declarations, statement of registrable interest, and reports of gifts forwarded by persons in public life. B, to examine declarations, statement of registrable interest, and reports of gifts, and to request from a specified person in public life any information or further information relevant to a declaration, statement of registrable interest, or report of a gift made by him, which may assist the Commission in its examination. C, and this is a section on which the Integrity Commission was acting, one of the sections in relation to which it was acting, to make inquiries and carry out investigations as it considers necessary, it being the Integrity Commission, in order to verify or determine the accuracy of a declaration, statement of registrable interest, or report of a gift filed under this ordinance. Subsection D below that then speaks to the Commission's function to receive, inquire into, and investigate any complaint or report of alleged corruption, act of corruption, or alleged contravention. So 4 is dealing with actual alleged offenses. And then at E, overleaf, it says to investigate
Could I just ask, Ms. Minor-Phillips, do you say that D was applicable in the circumstances of the present case?
I'm saying in the circumstance of no, my lords, because I'm saying we had not yet reached to that stage of there even being a complaint or an act of alleged corruption or misconduct.
Yes, thank you.
That in this case, the Integrity Commission was exercising its function under C.
Thank you.
Yes, my lords. So E, of course, then allows the Commission to investigate any matter under D of its own volition. And F speaks to examining the practices and procedures of public bodies in order to facilitate discovery of corrupt practices. And G is instructing, advising, and managing public bodies. And H, importantly, is to perform functions and exercise powers as it is required by this ordinance. As it is required by this ordinance, the Constitution, or any other ordinance. And of course, I'd like you also to look at subsection 2, just below that, that reflects what you previously saw at 97.2 of the Constitution, and it states, in the exercise of its powers and performance of its functions under this ordinance, the Commission may not be subject to the direction or control of any person or authority.
Now, I understood you to say a moment ago that one of the bases under which the Commission sought to act was subparagraph C. Is that the only one? Is that the only one that we're concerned with?
There is paragraph 43, which is the other basis, but I'm coming to that. I was going to take you to section 21st and then to paragraph 43, section 43, but I can take you to 43 if you wish to go there now.
No, I don't want to take you out of your order, but confining our attention for the moment to section 13 and the subparagraphs of section 13, you've said we're not concerned with D, that point had not been reached. Are we only concerned with C?
C, because we're saying that these are independent functions that the Integrity Commission has, that it can carry out any one of these functions at any one of its sittings, and that in order to carry out those functions, if any of those functions is amenable to or would be assisted by the issuance of a summons, it has the power to do so.
Yes, thank you.
Because what we're saying is that 13.1 is the arena or the domain within which the Integrity Commission operates, in the same way that a courtroom is a domain within which the judge operates. So this is essentially the Integrity Commission's domain. And even when I take you to 43, you will see that 43 is connected to 13.1c. So it's still a part of 13.1c.
Thank you.
Yes, Madam.
Before we leave 13.1c, what do you perceive the difference to be between inquiries and investigations?
Well, an inquiry is something, inquiry is wider. You can make inquiries, and then something can come up during the course of an inquiry which you think requires investigation. So I think what an inquiry is wider than an investigation. An investigation can come out or be born out of an inquiry, but I'm going to come to that also, hopefully.
And why did the Commission think that it was necessary to make inquiries or to carry out an investigation? Why did it do so?
Sorry, Mullers, I was getting some feedback. Could I just hear that
I do apologize. Why did the Commission consider it necessary to carry out an inquiry or an investigation?
In this case.
In this case.
In this case, all it was seeking to do, Mother, was to verify the accuracy of the liabilities listed in the grid in relation to the declarant. It was a part of its verification power. So in other words, it's not because you have listed your loans in the declaration, it is required to take it that what is there is correct or complete. It has a power to verify or determine the accuracy of what you put there. And that is that it can do by making such inquiries or investigations as it considers necessary.
But if it has some reason for concern that the returns may not be complete, and it thinks that information in the hands of the liquidator would be relevant, it can simply say, can't it, we'll open a formal inquiry and act under Section 46. I don't see anything that requires a formal inquiry to be particularly formal. It's just an announcement that we're going to exercise that power and conduct an inquiry to verify the completeness of the declaration.
It can do that, Madam, but that is one option open to it, and that is in the context of a formal inquiry. But it need not to do that. What the appellant is saying is that first it would summon the bank, look at the records that the bank has, do a comparison, and if everything is okay, then that's fine. There is no need to convene a formal inquiry.
But what difference does it make? Why does anything matter in this appeal? If there's some reason to want to see what the bank information is in order to verify the returns, why can't the Commission simply say we're going to have a formal inquiry to check whether any of these people has borrowed money from the bank which isn't shown up in their returns, and exercise the power under 46?
It could, my lord, but it would be highly cumbersome to have a formal inquiry every time.
Why would it be cumbersome? I don't see any particular cumbersome procedure that's required by the ordinance.
Yes, but it doesn't need to do that, my lord. It may, in its discretion, in the Commission's view, the Commission may be of the view that it can easily and more conveniently deal with this by first verifying the accuracy of the declaration, or seeking to verify the accuracy of the declaration under Section 13C, and then proceeding from there if it needs to.
But
and
46 specifically allows it to conduct an inquiry to verify any declaration. So it can simply say, yes, we intend to exercise the power under 46. Presumably it would have to have some reason to do so. But are you suggesting that the Commission could simply act on a whim?
It's not acting on a whim, my lord. It's part of its functions that it is that are given to it is a function to verify the accuracy of a declaration. So the verification of the accuracy of declarations is not something it would be doing on a whim. It would be something that it would be doing as part of its functions that it is required to do. And it may, if it chooses, conduct a formal inquiry.
Well, what's the problem with that? I haven't at the moment seen anything cumbersome about just saying that we wish to open a formal inquiry to verify these declarations. And then you'd have all the powers open to you that come with that.
But the appellant's case is that the power to summon also it comes with it being used to discharge its functions under 13.
Well, I know that's your case, but why does it matter a row of beans, if I could put it that way, when you have the power open to you very simply to exercise under Section 46?
Well, the answer to that, Manos, is that if it has the power, then it is up to the Commission how it wants to utilize it, because it's in its discretion and in its view how it wants to use its powers to carry out its functions. So if in its view it is more conveniently done in the way it was trying to do it, and once it is not prohibited by law, then that's fine. If it wanted to do it another way by commissioning a formal inquiry to verify each and every listing in one of the grids, then that's another way. But so long as it's not unlawful, then it is permitted to do what it's ought to do.
Ms. Minute Phillips, can I just ask you a question about Section 13(1)(b) and this particular case? 13(1)(b) refers to the Commission requesting from a specified person in public life any information relevant to a declaration. Was that done in this case?
It was not done in this case, my lord, because it didn't think that it needed additional information. It had the information that it needed. What it wanted to do was verify the accuracy of information it had. So it had received the information from the specified persons in public life. And now what it was embarking upon was steps that it considered necessary in order to verify or determine the accuracy of that information.
But you wouldn't say, would you? Are you saying this wouldn't be the normal procedure, that if one is concerned about a declaration, one might ask for further information from the specified person in public life who's put forward that declaration, rather than proceeding against a third party, i.e. the bank, to provide information?
But we're not saying that the information provided by the specified person in public life was deficient. All the Commission was trying to do is to verify the accuracy of what was there. And it's not going to do that by asking the provider of the information, is what you have said accurate? It has open to it tools to independently verify the accuracy of what has been sent to it. And that was what it was seeking to do.
Ms. Minot-Phillips, returning, forgive me, to section 46.
46, yes, Madam.
Are there any preconditions which have to be satisfied before the Commission may hold a formal inquiry?
I believe it tends to suggest that there is something requiring further delving into. That is what would trigger a formal inquiry under section 46.
I'm sorry, do carry on.
And stage that the Commission was at, it had not yet reached that point.
But so far as I'm aware, the statute doesn't prescribe a particular standard of suspicion or belief on behalf of the Commission before it can institute such a procedure.
No, I don't think there's any limit on the Commission's power to institute that procedure, my lords.
But it must presumably have a reason for instituting a formal inquiry.
Yes, and when you read the Act, you will see that there are certain cases where there is cause for concern or cause for or reason to come to a conclusion which could possibly be which could be an adverse decision to the specified person in public life, then you couldn't come to that adverse decision without first having had an inquiry and allowed the specified person in public life to be heard. So I think that is the precondition. If you're doing something that the result of what you're doing is going to result in a decision that is adverse to the specified person in public life, then you would have to have a formal inquiry and allow the specified persons in public life an opportunity to be heard before you could come to that adverse decision, and that you will see at 46 subsection 4.
You could simply have a concern, can't you, that the declaration might not be complete, and you want to verify its completeness.
Yes, and that is a part of your function too.
Yes.
And that is what we are saying was a concern that the Integrity Commission had, or that was a function that the Integrity Commission was embarking on in this case.
So presumably the Integrity Commission must have some concern that that there may be some incompleteness in the declarations, which is connected with the bank that's become insolvent, and it could then, if it articulates that concern, have a formal inquiry and request the information.
It could, but before it even reaches to that stage, as part of its verification function, which is part of its remit in order to determine the accuracy of the declaration that is filed, it could first summon the bank to see whether its records match with what has been stated by the declarant.
But presumably it's not just doing this, as you say, on a whim or some sort of random process. It must have, in fact, a reason. And isn't it in accordance with good practice and legality that it should have, if necessary, to have some reason before it acts?
My lords, yes, but part of its function is to verify the accuracy. So it is to examine each and every one of the declarations, and then it is to verify the accuracy of the content. And so in doing so, all may be well. And if all is well, we move on. In doing so, all may not be well, in which case it.
And can it summon witnesses as well on your case? Can it just say, well, we'd like to summon somebody as a witness to tell us what contact they've had with the person in public life and whether they've had any business dealings without holding a formal inquiry?
They wouldn't be doing anything further if all was well, man. If all was well, they would...
Sorry, are you contending that without holding a formal inquiry, the Commission can issue a witness summons to require a witness to come along and explain to the inquiry whether they've had any business dealings with a person in public life, for example? No formal inquiry, but just a witness summons to come to speak to a member of the Commission.
Yes, my lord, it can summon someone to come to its meetings and give it such information, evidence, documents, books, plans, whatever it wants. But it is at the point where it is of the view, or it comes to a view, that there may be something here which could result in something that is adverse to the position, to the person in public life about whom it is asking the questions, then it would launch a formal inquiry and invite the person, its specified person in public life, to attend and take it from there. But it doesn't have to do so initially as part of its verification function. I am saying, or the Integrity Commission is submitting, that in order to deal and to ensure probity and all of these good governance and all of these things that Section 102.2 of the Constitution says, it is given the remit to itself take such steps as it considers necessary in order to verify and determine the accuracy of a declaration. And it may do this, and in doing this, it can use its power to summon under Section 20. And if someone attends in response to a summon, and that person gives the Integrity Commission information which actually verifies the accuracy of the declaration, then fine, it moves on. But if the information that is forthcoming does not verify the accuracy of the declaration, then it may have a formal inquiry. And because there are so many items listed in the declaration, it is what the Commission considers to be the most efficient way of carrying out its duties. It's many specified persons in public life, many declarations, and it has a duty to verify each and every one of them.
Could I, sorry,
Figure me, my Lady Justice King has a question.
Ms. Minute-Phillips, is the position then that what your case is, that this Section 20 route, which can summon third-party witnesses, takes place without any knowledge of the person that's filed the declaration, without them having any knowledge it's happening, without recourse to either Section 43 or 44, or indeed, presumably, Section 18, and that's an appropriate route to leapfrog all those other investigative stages?
Well, not Section 43, my lady, but yes, that is our case. It can do that, and it may not, and it is only when something comes of it, or if something comes of it.
But let's just think of the...
It would be making...
I'm sorry.
Lady, I don't want to interrupt.
But inevitably, the consequences, therefore, given that you're saying this route can take place when there is no suspicion at that stage, you're simply following your duty, as I understand it, to verify. You're putting the person who's filed the declaration in the position that they have no knowledge that people who may be very important for their public life and reputation being called to give evidence. That you say is the appropriate route, is it?
Well, I'm saying I'm saying there's nothing wrong with that, because if it is that something comes of it and there is a prohibition against the Integrity Commission come to any decision adverse to the specified person in public life without that person being heard. So when it convenes a formal inquiry, we call the person, and the person would then have an opportunity to be cross-examined or whatever by the specified person in public life. But at this stage, when it is going through hundreds of declarations and trying to verify the accuracy, it can call whomever it likes, and to bring whatever plan, document, or information that it needs in order to verify the accuracy of the declaration. And Section C is quite clear. It says it is to make inquiries and carry out investigations as the Integrity Commission considers necessary in order to verify and determine the accuracy of the declaration, statement of registered interest, or report of a gift filed under this ordinance. And each one of these functions is a function it carries out it can carry out either together with or independently of any of its other functions. And I'm saying this is, it is not accidental that this comes at C, which is, so you get the declaration is filed, the declaration is examined. If you want additional information, you ask the specified person in public life. Then at C, you verify the accuracy of what is there. And then at D, if there is reason for a complaint, or there is some report of alleged corruption or an act of contravention, then you hold.
Sorry, may I interrupt you? Can I ask whether you say that the power to summon witnesses to attend and give evidence or to produce documents can be exercised without cause? There's no need to have any cause to summon them or to be able to show any cause. It can just be exercised without cause. Is that your case?
Yes, my lords. The same way that it was exercised by the Commission of Inquiry in the Bahamas in the Pindle case, where this board said there need not be a cause. Because at this point, what the Integrity Commission is embarking on is really fact-finding. And once the information that it is summoned, once the information that it seeks to get by way of summons is relevant to its terms of reference. Terms of reference include the terms of reference at 13(1)(c). Then a court should be very slow and very reluctant, or should just altogether shy away from saying that it cannot exercise its power to summons.
Ms. Minor-Phillips,
produce this information. Yes, my lords.
Forgive me. Let's assume that in a given case, the informal inquiry takes place using the power you say exists under Section 13 and under Section 20. And let's assume that that informal investigation discloses something which gives real cause for concern. Is there then an obligation to proceed to a formal inquiry under Section 46?
Yes, my lords.
Now, where do we see that in the scheme of the statute?
Well, where you see it is in 46(4), and that's repeated in other sections, where the Commission cannot give an adverse decision without giving the specified person an opportunity to be heard. So, in order to give them an opportunity to be heard, you would have to convene a formal inquiry.
Right. Thank you.
Okay, my lords. So, my lords, I had planned to take you next to Section 20 at page MS 323.
I do apologize.
I'm sorry.
But
I'm sorry, my Lord Stevens.
could we look at Section 18, first of all, and its interplay with Section 13(1)(c)? 13(1)(c) refers to an investigation. Section 18 enables the Commission to appoint an investigative officer. Can that investigative officer carry out the investigation under Section 13(1)(c)?
He could, but he doesn't have to, because the word may is there in 18(1). The Commission may designate a person employed under Section 17(1) as an investigative officer, and if you look at 17(1), it says the Commission may, acting within the funds and resources available to it, employ such officers or employees as are required for the proper performance of the functions of the Commission. So it could do it under 18, but it would be a delegation. Yeah. It would be a delegation to the investigative officer of a power that the Commission has.
Does that investigative officer have a limited right of access to documents? Because under Section 30, he would have to establish reasonable grounds.
Yes, because the legislation didn't intend to give the investigative officer, and certainly this is something that I have grappled with myself. But when I look at the scheme of the legislation, you see that it is clear that where the Commission is going to sit in a formal inquiry to adjudicate upon a complaint or an alleged act of corruption or an alleged contravention of the code of conduct, then in all likelihood, it would use the procedure of an investigative officer to acquire, to do the investigation pursuant to that. But in so doing, the investigative officer would be carrying out an overall function of the Commission, but the Commission itself would be distancing itself from that investigation. So the investigative officer, who is now delegated with the investigation function, if he wants a document, he has to go to a judge and get a production order and so on and so forth.
Why then should the Commission have greater powers than its own officer has?
Because the Commission does have greater powers than its own officer has. That's the short answer. The Commission itself can do all things that are necessary to carry out its functions, but where it chooses to appoint an investigating officer to do an investigation, that investigative officer would then be acting, I use the word independently of the Commission for the purpose of the investigation, would not go back to there would be a certain, it would be untidy for them to go back to the Commission to seek the very, the production of documents and so on and so forth, that the Commission itself, in an investigation that the Commission itself is trying to distance itself from by having its investigative officers do it for it. But that doesn't negate the fact that Section 20 is clear, that it gives the Commission a power to summon. And so that is where I would go next. I don't, having looked at it, I do not see that there is a tension between 18 and 13.
Ms. Minute-Phillips, we've been able to hear you, but we've lost the picture at the moment. I think you need to restart your camera.
My camera is on, my lords. Should I turn off my camera and turn it back on?
If you could, please.
Am I back now, my lords? I have done that.
No, not at the moment, but don't worry, we can hear you loud and clear. So we'll carry on, and we'll see if the broadcasting team can remedy the problem. Thank you,
my lords. I'll show you my camera is on, my lords. So I had intended to take you next, my lords, to Section 20.
Yes.
which is on MS 323. The Commission acting under this ordinance shall have the powers of a Supreme Court judge to summon witnesses and to call for the production of books, plans, and documents, and to examine witnesses and parties concerned on oath. And then I take you down to subsection 3. All summonses for the attendance of witnesses or other persons or the production of documents may be in Form 4 as set out in Schedule 2 and shall be signed by the Commission or any other member of the Commission, and oaths may be administered by the Secretary. And then I take you down to section 22. All persons summoned to attend and give evidence or to produce books, plans, or documents at any sitting of the Commission, and I'll come back to that, shall be bound to obey the summons served upon them as fully and in all respects as witnesses are bound to obey subpoenas issued from the Supreme Court. Now, my lords, the Commission sits anytime it meets to carry out any one of its functions and has a quorum of 4. So if you look at section 8 on MS 319, you see where it says the Commission shall meet at times as may be expedient for the Commission to carry out its functions. And at 2 it says a quorum of the Commission shall be 4. And then taking you back, if I could, to page MS 333, sorry, no, not 333. I was at 323, 323, going over on 324 and subsection 2, speaks about every person refusing or omitting without sufficient cause to attend at the time and place mentioned in the summons served on him, or any person refusing, or I'm skipping down, halfway down that paragraph, refusing or omitting without sufficient cause to produce any books, plans, or documents in his possession or under his control, and mentioned or referred to in the summons served on him, at any sitting of the Commission, commits an offense. Then, at paragraph 25, any summons to attend to give evidence or produce documents before the Commission shall be served on the person required to attend or produce the documents and shall be issued under the hand of the Secretary. Now, I am aware that the word shall appears in the first line of subsection 2, a summons under this section shall be in Form 4, but that shall is in conflict with the may that is in 20 subsection 3 on the previous page. And I think the form is basically for guidance, so it can't determine the extent of the power to issue. The form cannot be used to determine the extent of the power of the Commission to summon. And the form that is in this Act is clearly one that is drafted with 46(3)(b) in mind, which is where there is a formal inquiry and the specified person in public life requires the Commission to summon a witness to give evidence on his or her behalf. But that is not the only form a summons can take. So the next section
May I ask you something about the powers of the judge in your jurisdiction? If a judge issues a summons for the production of documents, does the person served with the summons have the ability to apply to set it aside on the grounds that there is no cause why they should have to produce the documents? Because certainly that was the case in English procedure when you could issue a subpoena ducis tecum, it was called, when somebody had to provide documents. They could argue that there was no sufficient reason why they should have to produce them and dispute.
Yes,
yes,
they can. They would come to the sitting and make that argument there.
And so, given that, why doesn't it follow here that the Commission should have to have the ability to show some cause to justify its summons calling for production of documents if the person on whom it's served asks for a reason why, or suggests that there's no reason why they should have to produce the documents.
Well, there is no cause at that point, because there's no party and party cause, or there is no whether or even similar to a civil or a criminal case. This is at this point an investigative or an inquiry that it is pursuing solely for a verification exercise.
But we recognise in court proceedings that issuing somebody with a summons and requiring them to attend and produce documents is not something that can be done arbitrarily. There has to be good reason for it. And if the person is reluctant to come, then a good reason has to be shown. Otherwise, the summons will be set aside. Why shouldn't the same apply to the Commission? That if the person on whom the summons is served says, well, why should I produce this document? Then the Commission has to give some reason for it. It can't just say, well, I don't have to say why, it's just, I'm just issuing it, just, there you are, turn up.
No, it will give a reason. Of course it has to give a reason, and it has in fact given a reason in the very summons, which I will take you to. It has to, of course, give a reason, my lords. But the long and short of it is that once that reason is a reason that is justified by its terms of reference, then the person has to comply with summons.
But the reason can't just be, well, I've got a power to verify something. It's got to be, I've got reason to think that you have information in your possession which I need to see in order to check the completeness of a return.
And that is exactly what the summons says, my lord. That is exactly what the summons says. And I'll take you to it if you would permit me in a short moment. I don't know if you want me to go there now, but I intended to take you to it. Before we did that, though, my lord, I just wanted to take you to section 43 on page 333. Under the head receipt and examination of declarations, the Commission, or the Governor, as the case may be, shall receive, examine, and retain all declarations and documents filed with it or him under this ordinance, and make such inquiries as it or he considers necessary in order to verify or determine the accuracy of the financial affairs as stated in the declarations of persons who are required to file declarations under this ordinance. So that is section 43, my lord.
Mm-hmm.
And there is so that said, now, my lords, I want to go back to my written case and ask your lordships to go to MS 145. MS 145, my lord, which is under the heading, what is the correct construction of the legislation, because of the concessions that we have had and to which my lord President referenced at the outset, I no longer have to deal with the issues at numbered paragraphs 23 through to 26. So I would, my lord.
Thank you.
Because the earlier part of that is 23 through to 24, is conceded by the respondent in their letter that my Lord President referenced at the outset, and paragraphs 25 through 26 are conceded in their written submissions, where they where the respondent distances himself from the court's conclusions that functions are not powers or don't include powers. So at paragraph 27 then, my lords, I'm saying respectfully, therefore, the decision of the Court of Appeal affirming the order and declaration of the Honorable Chief Justice requiring the consent of the person in public life before the Integrity Commission can compel by summons the attendance of the respondent before it.
Well, I think that point's gone, Ms. Miller-Phillips, as you say.
I didn't hear that, my lords. Could I ask you to repeat that?
Yes, that point's been resolved. It's conceded.
Yes, my lords. So I'm taking you down to 28. I just wanted to, I had just wanted to add the thought that or the question that now I think arises for your lordships as to whether, in light of the concession that the consent of the specified person in public life is no longer required, whether in fact the remainder of the respondent's case can survive that concession. Ultimately, it is a matter for your lordships. But the appellant very much doubts that at a formal inquiry, the words "at a formal inquiry," this is more easily done if I actually look at the words of the learned Chief Justice in her order, so which is at, I think it's MS 44. Is it MS 4? No, the words of the learned Chief Justice. Yes, MS 44. Yes, MS 44. In numbered paragraph 1. Outside of verification in the course of a formal inquiry and with the consent of the person in public life, the respondent has no power to compel by summons the attendance of the applicant before the respondent for the purpose of providing the respondent with information and documents relating to outstanding loans from the TCI Bank Ltd in liquidation to members of the House of Assembly.
Well, it's now conceded that the words "with the consent of the person in public life" would have to be deleted. You're going to explain to us why the rest of the respondent's case cannot stand after that deletion.
Well, I'm at this point, I'm wondering whether it can stand, my lord, because if you look at numbered paragraph 52 of the reasons of the learned Chief Justice,
Yes.
Well, that's the remaining issue, isn't it? Paragraph 52. That's the issue that we have to decide.
oh, sorry. Yes, my lord. I'm looking at, I'm trying to find it, just give per minute. Yes. It's at MS page 38, my lord.
Yeah.
The primary issue for resolution is whether the Commission's Section 20 power to issue a summons to a third party to produce documents can be exercised generally to assist it in carrying out its inquiries, or whether the power can be exercised only in connection with a formal inquiry under Section 46.
And your case, as I understand, is that because Section 20 doesn't say that the power can only be exercised in connection with a formal inquiry, it isn't restricted in that way, and it can be exercised whenever you like.
That is correct, my lord.
Yeah.
And because the primary issue for resolution has been linked with Section 46, it is Section 46 of the Integrity Commission Ordinance that says that a specified person in public life who is required to attend the Commission for a formal inquiry may require the commission to summon witnesses. So if it is that, the input into that order of the need for the consent of the specified person in public life derives from Section 46.
Yeah, but we're not concerned with that anymore because that's not relied on. It's simply whether there can be you can have a formal inquiry without the consent of the person being inquired into, can't you? Of course you can.
Formally, not if you are going to, not if the inquiry can lead to a decision that is adverse to him. Then you have
you've got to give them a chance to be heard, but you don't need their consent to issue a witness summons.
No, you don't need their consent to issue a witness summons. No. So, my lords, if you would go to Section 32, which summarizes our contention in relation to the summons issuing power, if I may call it that. Can I ask if your lordships are seeing me now on video?
No, we're still not seeing you, I'm afraid, Ms. Minard Phillips, but we can hear you loud and clear.
Okay, my lords. Section 32 says, not Section 32, paragraph 32 on page MS 148, Section 20 of the Integrity Commission Ordinance gives the Integrity Commission the power of a Supreme Court judge to summon witnesses and to call for the production of books, plans, and documents. Using the wider word persons, Section 22 of the Ordinance stipulates that all persons summoned to attend and give evidence or to produce books, plans, or documents at any sitting of the Integrity Commission shall be bound to obey the summons served upon them as fully in all respects as witnesses are bound to obey subpoenas issued from the Supreme Court. The Integrity Commission has the power to summon persons to attend to produce documents at any of its sittings, and it did so when it summoned the respondent.
I don't think you actually need to read out your case to us, Ms. Minard Phillips. We've all read it very carefully. The question really is whether you've got anything more you want to add to it.
Well, I would like to take you to the summons itself, just to show that, and that is at MS 45.
Thank you. Yes.
At MS 45, my lords, the actual summons issued. Now, this summons was, as you know from having read the record, it was issued and reissued, which is why two versions of it, or it appears twice in the record. But the content of both is virtually identical, so it will suffice if we look at just one. So at the first one that was issued, or the original summons, because the second one was a reissue. The original summons starts at page MS 45, and you will see that it starts out by referencing the ordinance at the very top of the page in the matter of the Integrity Commission Ordinance, and then right below that it says, in the matter of the examination and inquiries to verify the accuracy of declarations, a statement of register of interest and report of gifts by specified persons in public life pursuant to Section 13(1) and 43 of the Ordinance. And then under the word warning, it references Sections 20 and 22 of the Ordinance, which give it the power to issue the summons. And then on the next page, in the body of the summons itself, you will see that in addition to repeating the heading, it then goes on just below the words in capital letters to say summons to attend and produce documents before the Integrity Commission pursuant to Section 20 of the Integrity Commission Ordinance. And then it says, to Mr. Anthony Kikivarakis, official liquidator of TCI Bank in liquidation, whereas pursuant to section 13(1) and 43 of the ordinance, the Integrity Commission, the commission carrying out the examination inquiries to verify the accuracy or otherwise of declarations, etc., etc. And whereas it has been made to appear to the commission that as the official liquidator of the TCI Bank, you are likely to have in your possession and or control information and documents of any outstanding loan of specified persons in public life, and for the period set out in Appendix 1 to this summons, and that you are able to produce those documents and information aforesaid, this is to require you to appear before the commission at the offices of the commission at, and it's the address, on the 30th day of June 2016 at 10 a.m. So that is the details of the sitting of the commission that he is required to attend, to produce any and all documents and information in your possession or control relating to any outstanding loan of the specified persons in public life, and for the period set out in Appendix 1. And if you turn the page, you will see Appendix 1. And Appendix 1, which continues onto page 48, sets out the 21 named persons in respect of whom the TCI Bank is asked to bring information in relation to their loans that they have with the TCI Bank, so that the commission can verify their liabilities to the TCI Bank. And the periods are set out there, March 31, 2010, March 31, 2012, March 31, 2014, and March 31, 2015. And here you see the, on page 48, you have names 1 through 10, and, sorry, 47, you have names 1 through 10, and on page 48, you have names 11 through 21. So there can be no doubt, this is the submission of the appellant, that there can be no doubt that the information sought is relevant to the Integrity Commission's terms of reference that are set out in sections 13 and 43 of the Integrity Commission Ordinance. So that then, my lords, is the summons that on the application of a respondent was quashed by the Honorable Chief Justice as she then was, making the order that you have just looked at MS 44. And that order was, that order of the Chief Justice, of the Honorable Chief Justice, my lords, was confirmed by the Court of Appeal with its order dismissing the appeal of the Integrity Commission, which you will find at MS 27 if you need to reference as the formal order of the Court of Appeal dismissing the Integrity Commission's appeal. Now at MS 128, my lords, you have what is an agreed précis between the appellant and the respondent. And I think the issues before your lordships that arise from the dismissal and grounds of appeal are succinctly set out in the questions that in question form in that précis at the 3 bulleted items at the bottom of the page. And I will now read each question and provide you with the appellant's answer to it. So the issues in the appeal are whether the restrictions placed by the courts below on the power of the Integrity Commission to issue a summons are inconsistent with the discharge by the Integrity Commission of its function as an institution protecting good governance. And the appellant's answer to that is yes, they are inconsistent. The second question is whether on these facts, the summons issued by the Integrity Commission was ultra-virus its powers. And the appellant's answer to that is no. It was not ultra-virus its powers. And the third question is whether the Confidential Relationships Ordinance applies to confidential information given to or received by any person in accordance with the provisions of the Integrity Commission Ordinance. And the answer to that is it does not apply. So, my lords, the only issue I think that that remains for me to address your lordships would be the issue of the Confidential Relationships Ordinance. And if you look at, if you go with me, my lords, kindly to MS 382 to 383, it says, subject to subsection 2, this ordinance shall apply to all confidential information. And then subsection 2 says, this ordinance shall not apply to confidential information given to or received by, and if you turn over leaf and go down to item E, any person in accordance with the provisions of any other ordinance. So that once, if it is that the Integrity Commission does have the power to summon that the Act says it has, and if it issued the summons in accordance with that power, and if the liquidator of the bank attended before it and gave it information, then that would be information received by it pursuant to another ordinance, which is the Integrity Commission Ordinance, and therefore the Confidential Relationships Ordinance would not apply. Now, I am almost at the end of my presentation, fellas, but I would just like to, and I'm not going to read it, but I would like to just ask your lordships to take note of the pending case, and the pending case is to be found at MS 437. It's a decision of your lordships board. And it was an action seeking to quash a summons issued by the Commission of Inquiry to bank managers requiring the production of documents. At first instance, the court upheld the issue of the summons on the challenge, and the Court of Appeal quashed that, allowed the appeal and quashed the summons. And then it came before your lordship's board, and your lordship allowed the appeal and reinstated the summons. And there are a lot of things in this case that I think run parallel to the case that of the Integrity Commission.
Am I right in understanding that this case involved a formal inquiry?
This case did involve a formal inquiry.
So the fact that you can issue a witness summons in connection with a formal inquiry doesn't assist your argument that it can be issued without a formal inquiry?
And the question, the broader question before this court in that case was whether the summons was issued in accordance with the terms of reference of the Commission. The terms of reference of the Commission were included the holding of a formal inquiry. So what the appellant is saying in the case at bar is that what is now equally before this court is the validity of it issuing a summons that is in accordance with its terms of reference. And once it is in accordance with its terms of reference, then Pindling would apply, because all Pindling is saying is that when what is being carried out is not a party and party cause, but an inquiry, and you're seeking to gather information. Once that information is relevant to your terms of reference, you should be allowed to pursue it. And the only balance, as I had quoted, that needs to be struck is that between the public interest and the private rights of the individual, and the private rights of the individual have to give way to the public interest. And certainly the public of the Turks and Caicos Islands has a vested interest in having the Commission verify the accuracy of the declarations filed by the specified persons in public life who are acting on its behalf and perpetuate. But at page 901, you will see that the board said that there were no legal proceedings to which anyone was a party. As in this case before you, there are no legal proceedings to which anyone is a party. Yet the Commissions of Inquiry Act is clearly designed to enable a commission to obtain such access, that is access from the banker in appropriate cases. I'm reading on MS page 448. And the section 10.3 of the Commission of Inquiry Act that is referenced there is the Commission of Inquiry's power to summon persons to come before it. And so just below the end of that paragraph, just to look at the section where it says, given that there is no hurdle in the shape of a special cause to be surmounted, so just as here, there is no special cause, there was no special cause there, consideration falls to be given to the manner in which a commission of inquiry should direct itself in deciding whether or not to issue a summons giving it access to entries in bankers' books. And it says, and then it goes into this lovely paragraph about that it's not helpful to approach the matter by reference to court proceedings. Because if you look at paragraph F, it then goes on to say, by contrast, the Commission of Inquiry starts with no specific issues or charges. And this is where the Integrity Commission is here. There are no specific issues or charges. It has only its terms of reference, which may be extremely wide, which they are under Section 13 in the Integrity Commission Act. Its function is inquisitorial, not adversarial. And that is the case when it is seeking to verify the accuracy of declarations. It is inquisitorial function that it is carrying out, not an adversarial one. It must pursue lines of inquiry, and it so may find that other lines of inquiry appear to be requisite, including investigation into an individual company's bank accounts. And then on the next page is a dicta about the only balance which needs to be struck. But on page 903 at letter C, you'll see that this board then said, however, I think a court, if it has the power to do so, should be very slow to restrain a commission from pursuing a particular line of questioning and should not do so unless it is satisfied, in effect, that the commission is going off on a frolic of its own. And pausing there for a moment, this commission cannot be said to be going off on a frolic of its own in seeking to do that which the legislation specifically empowers it and requests it to do, which is to verify the accuracy of the declaration filed with it. If there is a real as distinct from a fanciful possibility that a line of questioning may provide information directly or even indirectly relevant to the matters which the Commission is required to investigate under its letters patent, such a line of questioning should, in my view, be treated as relevant to the inquiry. And relevant to its letters patent takes you back to what were the terms of reference of the Commission of Inquiry that was sitting in the Bahamas. And because it was a Commission of Inquiry, its terms of reference involved that. But here, the terms of reference are set out in Section 30. So on page 904, at letter C, it says, if there is material for the Commission which induces in the members of it a bona fide belief that such records may cast light on matters falling within the terms of reference, then it is the duty of the Commission to issue the summonses. And at D to E, it says, in particular, the decision of the Commission should not be set aside unless it is such as no reasonable commission correctly directing itself in law could properly arrive at. This is the Westbury test, and we're saying that it cannot be said that in issuing this summons that the Commission must be taken as having done an act which no reasonable commission could possibly have done.
Well, the Commission hasn't given any reason for its act. You haven't said that the Commission has any material before it which induces the belief that this information is going to be relevant. We don't know, for example, whether there are declared loans to these individuals, and the Commission's got some reason to think that they might actually have borrowed more. or whether there are
Yes.
no declared loans and the Commission has some reason to think that there might be some undeclared loans, or whether the Commission just thinks it would be a nice idea to find out whether by any chance any of these people has borrowed some money, but has no reason for thinking that it might have. All that
No,
is undisclosed.
No, my lords, we do not have the declarations that were subject, that were before the Commission, before the court.
No.
But I've taken to the form, and I think you can safely come to the conclusion that there would have been liabilities listed in the section under the grid, under the 3 pages of grids, all the various loans that all of these people had. Some of which no doubt could have been with the Turks and Caicos Islands bank, the TCI Bank. And it is specific persons. It's not just as all the House of Assembly. Don't come. It hasn't asked him to come and give information in relation to every member of the House of Assembly. It has asked him to come and give information in relation to the named persons set out in Appendix A. So clearly the Commission must have had a basis for asking for information in relation to those persons. It is seeking to clarify, to verify, verify the accuracy of the declarations of those persons filed with it. And it is not only seeking to do so, it is required by the Integrity Commission Ordinance to do so. And so it is carrying out its function under its terms of reference. So my lords, those then are the appellant's reasons for its answers given to the 3 agreed issues set out in the précis, and those are also its reasons for requesting you to allow this appeal. Unless I can be of any further assistance to your lordships, that is the case of the Integrity Commission.
George, do you want to rise? Rise to take stock? Oh, I see. Yeah, we could do, yeah. Thank you, Ms. Minute-Phillips. We're grateful to you. We're going to rise for a few minutes in order to take stock of where we are. And while we're doing that, I hope it may be possible to see if the visual link to Ms. Minute-Phillips can be restored. Court will rise. Mr. Missy.
Yes, thank you. Thank you, my lord. My lady. There are 2 issues which the board has to determine. First is the construction of Section 20 of the Integrity Commission Ordinance, and the second is the applicability of the Confidential Relationships Ordinance to these proceedings.
Yes. Mr. Missick, I'm sorry to interrupt you. You're rather quiet. We can hear you, but you're rather quiet. I don't know if it's possible to adjust the volume.
Let me try my... Yes, I'm showing it 100%.
Right. Well, you can't do more than that. We'll press on and see if we can do anything at this end. Perhaps you could keep your voice up. That would help. Thank you very much.
Thank you. What I propose to do, my lord, is to put forward the respondent's position in relation to the interpretation of Section 20, and then address the arguments and criticisms of the judgments below advanced by the appellant. and then I will make very brief submissions on the Confidential Relationships Ordinance. The respondent's case is that the courts below were correct to hold that the appellant had no power under Section 20 to issue the summons, the subject matter of these proceedings, and to set aside that summons. The basis of those decisions is that Section 20, when read in context, limits the powers of the IC to issue a summons to those situations where it is exercising an inquisitorial function. The function in respect to which the summons was purportedly issued was the verification of the accuracy of declarations, statements of interest, and report of gifts by specified persons in public life under Section 13(1)(c) and 43. The board has seen the summons, which was brought to your attention by my learned friend. These functions are not inquisitorial. This interpretation derives from the plain language of Section 20, which defines and limits the power of the IC to issue a summons by reference to the powers in that respect exercisable by a judge of the Supreme Court. It is common ground that a Supreme Court judge may only issue a summons where there are pending proceedings before it, and then only on the application of parties to those proceedings. Circumscribing the power of the IC by reference to those exercisable by a Supreme Court judge provides a measure of accountability and discipline to the IC when issuing summonses. There is a body of case law dealing with when it is appropriate to issue a summons to third parties to give evidence and produce documents, and what documents may be summoned. By Section 20, the legislature has provided that the IC is to be guided by this body of case law. But the reference to the powers of the Supreme Court judge is not the only indication in Section 20 of the limitation of the IC's powers to issue a summons, because Section 20, having stated that the IC is to have the power of a Supreme Court judge, goes on to say, and you will see that at Electronic Bundle 323, Section 20, having issued the summons, the IC has the power to call for the production of both plans and documents, and then to examine witnesses and parties concerned. The reference to parties concerned indicate that there is some sort of inquisition or inquiry into the conduct of a person who is in a similar position to a party to proceedings. The interpretation by the courts below is supported by other provisions of the ICO, and in particular Parts 3, Parts 5, and Part 6. Part 3, or Section 20, is contained in Part 3, which is headed Procedure of the Commission. A review of the subsequent sections of Part 3, i.e. Sections 21 to 27, shows that this procedure is only applicable to inquisitorial type proceedings. For example, it contains provisions for protection and rights of persons appearing before the IC as witnesses and of their obligations and liabilities. It also contains protection for persons who may be the target of such proceedings because of their conduct. Turning to specific sections, Section 21 says any witness who shall willfully give evidence in an inquiry concerning the subject matter of an inquiry commits perjury. The reference to subject matter indicates an inquisitorial process. And could only mean a formal inquiry. Then section 23 section 22, still on page 323, says a person summoned to attend and give evidence or produce book plans and documents at any sitting of the commission. Now, my learned friend indicated that in her view, the word sitting meant any meeting of the commission. In the respondent submission, the word sitting is indicative of a formal hearing, as when a court or tribunal is sitting to hear and determine a matter, and not a routine meeting of the commission. Then we go to section 23. It says any person whose conduct is the subject matter of an inquiry. Again, indicative of an inquiry into someone's conduct. And it goes on to talk about, or anyone who is in any way implicated or concerned in the matter under inquiry, having the same effect. Then in section 26, it says the commission may report, this is on page 325, that's on bundle 325, the commission may require any facts, matters, or things relating to the subject matter of the inquiry. Subject matter indicating that there is an inquisition into a matter which needs to be resolved. And then there's the form of the summons, which presupposes the existence of a formal inquiry, because it refers to evidence on behalf of a complainant or a person in public life. Then turning to part 5, which is at page 330 to 337. And in particular, starting from paragraphs 43 to 46, when those sections are read, you will see that there are 3 methods by which the IC may probe declarations. The first is to make general inquiries under section 43B. And in answer to the question posed by the board to my learned friend, we would submit that inquiries and investigations are the same. And in relation to section 43B, the words make such inquiries shows that it is a general inquiry and not an inquisitorial inquiry. Otherwise, the legislature would have used the words conduct instead of the word make. The second method of probing is to request written particulars from the declarant under section 44, and incidentally also under section 13(1)B, to which I was referred to earlier. It says to examine declarations, this is on page 320, examine declarations, statements of registrable interest, and reports of gifts, and to request from a specified person in public life any information or further information. Section 44, on page 333, the Commissioner or the Governor, as the case may be, in writing, requests a declarant to furnish such further particulars relating to his financial affairs as may be considered necessary for the purposes of Section 13(1)(b). And then there's Section 46, which is divided into two limbs. The first limb deals with a request in writing to the declarant to furnish further information or documents. Then there's the second limb, which provides for the conduct of an inquiry to verify any declaration and other statements.
Can I ask you whether you say there's any precondition that must be satisfied in order for the Commission to conduct an inquiry to verify a declaration under 46(1)?
In my respectful submission, my Lord, no, in the sense that there are no set criteria, but obviously it would be frivolous for the Commission to simply embark on a formal inquiry just for the sake of it.
Yeah.
There must be some basis upon which it can reasonably believe that an inquiry would yield or would assist it in the verification process.
Well, do you accept that in this case, if the Commission were to, let's say, provide a witness statement explaining that it has some basis for thinking that the declarations of the people named may be incomplete because they may have borrowed money from the bank which wasn't declared, that they could then open a formal inquiry and issue a summons to produce the banker's books?
Yes, my Lord, yes, that, yes, yeah, I accept that.
Thank you.
So moving on, the third method is under Section 46(1) is to conduct an inquiry. And an inquiry under Section 46(1) is of course an inquisitorial inquiry, because the person in public life is required to appear before the Commission under Section 46(2) and to be heard on any matter in relation to it. And then you would see that under subsection 3, a specified person in public life who is required to attend the Commission may require the Commission to summon a witness. No such request can be made by a person in public life to the IC when it is exercising its other powers, i.e. those under Section 13(1)(b) or 43(b) or Section 44 or the first limb of Section 46. And without going, there are similar provisions in relation to Part 6 regarding the proving of registrable interest. And so we would submit that the legislature has made a policy distinction between the investigative and administrative functions of the IC on the one hand and its inquisitorial functions on the other hand. A person in public life, when faced with an inquisitorial proceeding, may ask for the summoning of a witness, but not in any other, but not when the IC is exercising any of its other functions. And we would submit that there's good reasons for this policy distinction. It is one thing to request in writing a person in public life to provide further particulars information and documents concerning his own affairs. It is another to compel a third party to summons to produce confidential information concerning the financial affairs of a person in public life, as a matter of routine. It would be even more concerning when the person in public life was not given an opportunity to voluntarily provide the statements, or the information and the documents, which the IC clearly has the power to require them to do. And when the person in public life does not even know that his private confidential information is being provided by a third party to the IC. This policy, which we say is apparent, is consistent with the values of a democratic society which subscribes to the rule of law. Democratic societies do not normally confer powers on public bodies to issue summons to third parties to solicit private banking information of persons in the absence of wrongdoing, or at least some suspicion of wrongdoing. Any other interpretation of Section 20 would be inconsistent with Section 9 of the Constitution, which you will find at.
But I think you accept, Mr. Mizik, that although you use the word wrongdoing, it may simply be a reasonable suspicion that the declaration filed is inaccurate or incomplete. It doesn't have to be a suspicion of corruption or something like that.
I accept that, my lord. Perhaps I use the word wrongdoing not in the sense of any criminal liability, but perhaps some sort of a contravention or in the completion of the declaration.
Yeah.
Some failure in the completion of the declaration.
Thank you.
Mr. Mizik, could I ask you a question back really on the question as to what is necessary to trigger? I think we might have lost the picture again. Can you still hear me, Mr. Mizik?
Yes, I can hear you, my lord.
We've got the picture back. I'm just pressing you on what is required to trigger a formal inquiry in the sense that you're talking about. Say, for example, the Integrity Commission had done exactly what it did here, but had prefaced the summons by a statement to the effect of, we have opened an inquiry, or we are opening an inquiry into the declarations made by specified people. Is that all that's required? I mean, where is the requirement to inform the specified people that one is opening an inquiry? Where's that coming from?
Well, my lord, for this reason, you can't have an inquisitorial process into the conduct or lack of or failure of a person without allowing that person to know the nature of the inquiry that you are conducting.
Is that something you are telling us as a matter of law, or is it laid down in this particular ordinance? Because if you look at Section 46, there's nothing about having to inform anybody.
No, Lord, I'm not relying on any express provision of the ICO, but as a matter of elementary fairness, one would expect that if an inquiry is to be launched into the failure to properly complete the declaration or filing a false or declaration which is false in any material respect, then as a matter of common fairness and justice, one would expect the person in public life to be notified, unless there are reasons not to do so. For example, if notification of the person would lead to loss of evidence or destruction of documents or something of that nature.
So if I could just press you then, the trigger for a formal inquiry, as you've just put it to us, is that the person being inquired about has to be informed.
Yes, my lord, I would say, yes, my lord, I would say that is the case. The person has to be informed that an inquiry is on foot.
Thank you.
And if I can just ask your lordships and my ladies to have a look at section 50, which deals with inquiry. It says, well, no, I take that back. That is dealing with a tribunal appointed for the purposes of examining a declaration of a member of the commission. So I leave that aside.
Mm-hmm.
I was about to refer the board to section 9 of the Constitution, which is at page 252. Which provides that every person has the right to respect for his or her private and family life, his or her home, and his or her correspondence, and accept with his or her own consent. No person shall be subject to search of this person and so forth. Then section 2, nothing in any law or done on its authority shall be held to be in contravention of this section to the extent it is reasonably justifiable in a democratic society. And then A, in the interest of defense, public safety, public order, public morality, public health, and so forth. So we would say that the provisions of the Integrity Commission Ordinance, which provides for the release of information by summons and from the declarants and so forth, are reasonably justifiable in the interest of public morality. But there is no justification on public morality grounds for the Integrity Commission to be able to summon third parties to obtain private banking information of a person in public life when there is no suggestion that the information provided by those persons is in any way incomplete or misleading. And in particular, because the law itself provides other means by which information and documents relevant to the verification of declarations and statements of registered interest can be verified without the coercive powers of issuing a summons to a third party. So on that basis, we submit that the courts below were correct in its interpretation of Section 20 and can I now address some of the arguments raised by my learned friend against that interpretation. First, it is said that there are no words in the Constitution or in the Integrity Commission Ordinance which confines the power to issue a summons only when the IC is conducting a formal inquiry. The contention is that the IC may issue a summons at any time it is embarked on the exercise of any of its functions under Section 13. We would say this is to ignore the reference to Section 20, that the power is exercisable only by reference to that exercised by a judge of the Supreme Court. The appellant seeks to gloss over the reference to the power of the Supreme Court by saying, and this is at paragraph 48 of our written case, that the powers of the IC and the Supreme Court judge are the same, but that the parameters in which the powers are to be exercised are different. And she placed great reliance on the case of Douglas against Pending, which is at page 437. And I will come to refer your lordship to a passage in that case shortly. But the proposition she seeks to rely on is that as long as the summons is issued in connection with one of the functions of the IC, it is within the IC's quote-unquote terms of reference. Douglas versus Pending, in our submission, does not assist the appellant, apart from the fact that it was itself a case dealing with an inquisitorial formal inquiry. It was concerned with the powers of a commission of inquiry to issue a summons under the relevant Bahamian legislation. And as the board noted at page 901, after G, this is the passage to which the board was already referred, that a commission of inquiry only has terms of reference. At page 448 of the bundle, by the letter F, the board in that case said this: by contrast, a commission of inquiry starts with no specific issues or charges. It has only terms of reference, which may be extremely wide, as they are in the present case. Its function is inquisitorial, not adversarial. It must pursue lines of inquiry, and in doing so, it may find that other lines of inquiry appear to be requisite, including investigations into some individual or company's bank account. So, as with an inquiry under Section 46, the functions of a commission of inquiry is inquisitorial. A commission of inquiry has no freestanding administrative investigative functions outside its inquisitorial remit. It is given power to issue summons to pursue specified lines of inquiry, as the case demonstrates, and other lines of inquiry which are necessary. The inquisitorial nature of a commission of inquiry is seen, or can be seen, when one looks at Section 2 of the Commission of Inquiry Ordinance, which is at page 618. Section 2 says, the governor may appoint one or more commissioners, hereinafter referred as commission, to inquire into the conduct and management of any public body, the conduct of any public officer, or any matter whatsoever, which in his opinion is of public importance. So that shows the specificity of the matters which a commission of inquiry used to be appointed for. But it gives it no other broad administrative or investigative functions. By contrast, the mandate of the Integrity Commission is much broader. It is a permanent institution with statutory functions, but no specified terms of reference. It exercises administrative, investigative, verification, and advisory functions, as well as inquisitorial functions. And we would submit that if the legislation intended that the Integrity Commission was to have a freestanding power to issue a summons when performing any of those functions, there would be no need for the reference to the Supreme Court judge. And it is notable that under Section 4D of the Commission of Inquiry Ordinance, which gives the Commission of Inquiry the power to issue a summons, there is no such reference. Section 4D is at page 619. And it says, 4.1, a commission may, for the purpose of complying with the directions on this screen and for conducting the inquiry generally, summons any person in the form set out in the schedule to attend, to give evidence or to produce any articles or documents. No limitation by reference to the Supreme Court.
Sorry, Mr. Mizik, I'm afraid I lost that reference. Could you help me with it again?
Yes, page 619.
I think it's
that is in the supplementary bundle.
A separate bundle.
Yes, but it's the pagination is running in line with the other bundle, with the record.
It's actually page 2 of the supplemental bundle.
Thank you very much. Thank you.
Thanks. Finally, the appellants contend that the construction of Section 20, adopted by the courts below, would curtail the Integrity Commission in the exercise of its functions of verification of declarations, statements of registrable interest, and report of gifts. Now, at paragraph 37 of the appellant's written case, that is at page 149, it is suggested that the interpretation would require the convening of a formal inquiry every time the IC is to carry out its functions of verifying or determining the accuracy of declarations. But there's nothing in the judgments below to indicate that the power to verify declarations can only be done in the context of a formal inquiry. There's nothing in the judgments to say that.
Mr. Mizik, you couldn't just, sorry, Mr. Mizik, could you just remind me, all these declarations are published, is that correct?
They're available for inspection by the public.
By the public, yeah. So the press and the public can gain access to them, and
yes.
And that is a method of making available to the public a method
yes,
of checking whether they're accurate.
Yes. Then at paragraph 44 of a written case, the appellant asserts that the court below regarded the verification function set out in section 1C and 4th Street as capable of being carried out only in the context of a formal inquiry. And again, there's nothing in the judgment which suggests that. That is an unfair reading of both of those propositions, or those statements are unfair reading of the judgments.
Could I take you back, Mr. Missick, to the trigger, if I can call it that, for a formal inquiry?
Yes.
Would that include reasonable grounds for suspecting that the declaration was incomplete? Would that include hearsay evidence?
Yes, no, I would say so, because the commission is not a court, and it says it can make its own rules. So, subject to any rules to the contrary, I would say yes.
Would it include an anonymous information?
I would say not, my lord, because that would, unless the anonymous information was somehow capable of showing that there was some merit or some degree of accuracy in it. Unless, of course, the anonymous person, unless there's reason to believe that the anonymous, well, when I'm talking about anonymous, I'm talking about someone whose identity is unrevealed. But if the reason for the anonymity is that there was some sort of fear in the person who produces the information, then I think obviously that would be something that the commission can take into account in deciding whether to launch an inquiry. But if it was simply, the person was simply being anonymous without having any fear or reason not to disclose its identity, then I think that would be problematic.
Yes.
And then on the question of whether the interpretation advanced by the respondent and accepted by the court below, whether that interpretation would derogate from the commission in the exercise of its powers, we would submit not, because that interpretation does not affect the other powers which the commission has to probe declarations to determine their accuracy. And those powers, as we've already seen, are to be found in section 13(1)(b), section 43, section 44, and the first limb of section 46(1). There's nothing to suggest that the exercise of these powers would not be efficacious. And if, in any particular case, the exercise of one or all of these other powers turn out to be ineffective, it is always open to the IC to launch an inquisitorial inquiry utilizing the powers under the second limb of section 46(1). And summoning witnesses. The IC is not required to exhaust or even initiate any of those steps under section 43 or section 44 or the first limb of section 46(1) before issuing a summons, provided it is a formal inquiry. It is entirely up to the IC to decide in any particular case whether to proceed under one of those sections first, or at all, or whether to conduct an inquiry under the second limb of section 46(1) from the outset.
Mr. Missick, I'm sorry for interrupting again, but as I understand it, you have a distinction between administrative functions under section 13 and inquisitorial under Section 46. Do you accept that the Commission can appoint an investigative officer to assist in an investigation under Section 13(1)(c)?
Yes.
And wouldn't that be inquisitorial rather than administrative?
No, my lord. I would submit that would not be an inquisitorial, because the function, inquisitorial is, I use the word inquisitorial in the sense that the Commission is seeking to probe conduct or behavior, whereas an investigative officer is simply ascertaining facts, which then goes to the Commission, and on the basis of which the Commission can make decision, one of which may be the holding of an inquiry. It's an investigative function. The administrative function is, of course, is receiving the declarations. The investigative function is probing into those declarations by examining them, by making further inquiries of the person in public life, by asking the person in public life to produce further particulars and to produce further documents. It would also be open to the Commission, subject to any legal restraint, to obtain statements from third parties. For example, if a third party has in his or her possession information which is already in the public domain, or who may be knowledgeable about certain aspects which go to the accuracy of the declaration. But that is a different thing from compelling a third party to appear before the Commission to give private information, private and confidential information concerning the banking affairs of a member of the House of Assembly. And so we would say that it is how the Commission proceeds is its own choice. But if it wishes to issue a summons, it may only do so by holding an inquiry in the case of a declaration under the second limb of Section 46(1).
And do you accept that where a summons is issued in the context of a formal inquiry, it overrides confidentiality obligation?
In the case of a valid summons, yes.
Yes.
But not in the case of an invalid summons.
No, certainly.
And that is the nub of our submissions in the context of the Confidential Relationship Ordinance.
Mr. Mizik, are you therefore, in that submission, contradicting what the Court of Appeal said? because, as I understood it, the Court of Appeal in its decision, I'm looking particularly at paragraph 70, seemed to take the view that even if the summons was valid, that is, within the Integrity Commission's powers, nevertheless, there would be no defence to the offence under the Confidential Relationships Ordinance.
Well, my Lord, that is what that is the import of the Court of Appeal's judgment, and I would venture to say that I was troubled by that to the extent that it excludes, it might exclude confidential information given to the Integrity Commission, even in the context of a validly issued summons.
In paragraph 71, they do refer to certain sections of the ordinance applying to the Commission, but they don't mention sections 20 and 46. I think you're telling us that you would accept that one ought to add to the list of 28 to 38, 46 combined with 20 as well.
Yes, my Lord, yes. Otherwise, it would be difficult for the Integrity Commission to mount an inquiry if it has to, if it was not able to obtain those documents.
Thank you.
Yes. But the gist of our submission is that in this case, because there was no valid summons, none of the provisions of the Integrity Commission Ordinance, which allows the Commission to receive those documents from Mr. Kikivarakis, were protected under the Integrity Commission Ordinance. So those are the respondent's submissions.
Can I just ask you about one paragraph of your case, Mr. Missick?
Yes.
On page 165, paragraph 34.
Sorry, my Lord, page?
165 of the bundle.
Yes.
Paragraph 34, you refer to the power of the Supreme Court to issue a summons.
Yes.
And you mentioned there that a summons can only be issued in the Supreme Court on the application of a party to the proceedings.
Yes.
Now, would I be right that you accept that in the context of the commission inquiry, because it's an inquisitorial, not an adversarial procedure, the Commission can act of its own motion in issuing a summons? Or have I misunderstood that?
I do accept that, and that is one of the reasons why I made the concession yesterday that the consent or the requirement of a person in public life is not necessary for summons can be issued.
Thank you.
Thank you, Mr. Missick. We'll rise now and we'll resume at 2 o'clock.